Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the Free Legal Advice Show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I am able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your questions are relating to the English legal system, English legal questions, please feel free to get in touch with us. Two ways to get in touch. First of all, if you want to speak to me live on air, please ring the landline number which appears at the bottom of the screen. Alternatively, if you want to send me a message, a WhatsApp message with your question, then you can do that on the mobile number which also appears at the bottom of the screen. So for live calls, it's the landline number, and for messages, it's the mobile number which is there at the bottom of the screen. The latter method is quite a popular method. People don't necessarily want to come live on air and discuss their personal confidential matters. So it's a very popular way of getting in touch with us, simply to send us a message on WhatsApp. I do get it here and I've already started receiving some of your messages which I will be dealing with as we go along. So either way is absolutely fine. Landline number for a live call and the mobile number for a WhatsApp message with your query. A couple of minor points before we get going. On a live show, it's not always possible to take very detailed information from callers who call in. Sometimes it transpires that the matter is quite complex. Sometimes it transpires that I do need to look at your documents before I can advise you. It could be that you've received a letter from another firm of solicitors, or it could be it's an immigration matter and you've received a letter from the Home Office. Now, if it's the case that I need to have an in-depth discussion with you, or I need to look at your documents before I can advise you, then I will ask you to leave your number with the control room and I will call you back off air. That will be completely free of charge and part of the free legal advice that we provide as part of this show. So to get in touch, the landline number is there and the mobile number is also there for WhatsApp messages. As I mentioned earlier, just before we came on, we had a number of questions already coming in, which is fantastic. Please keep on sending your questions in and I will address all of them during today's show. First question that's come in, and immigration is always a very popular topic. The first question that's come in relates to a fee waiver application. So let me read the question out and then let's go through it. Question is this. So our viewer is asking, I want to know how long a fee waiver application for a FLR FP extension application will take to be processed. So for the benefit of our viewers who don't necessarily understand what's been asked here, what this fee waiver is about, what this FLR FP application is about, let me give some context for the benefit of our viewers before I specifically address that question. FLR FP application is normally an application which is made by somebody who has limited leave to remain or has no leave to remain in the United Kingdom, and they want to extend their visa, normally based on family life or their private life in the United Kingdom. It's a human rights type of application where somebody is wanting to stay in the UK based on family or private life that they've built up in the United Kingdom. And FLR FP applications, they've existed for a while. The good thing is that if you are struggling to pay for the Home Office fees, and they are significant, if you are struggling to pay for Home Office fees, you can apply for a fee waiver. Now, there's no guarantee that the fee waiver will be granted, but there is that avenue there. If you are extending your application using form FLR FP, so it's some kind of family-based or private life application, and it's on that basis you're extending, and you can't possibly afford to pay the fees that you have to pay to the Home Office, there is a possibility of applying for a fee exemption. Now, The fee exemption could possibly mean that you don't have to pay the application fee, which is normally in the region of £1,000 or just above £1,000. And if it is successful, it is possible that you won't have to pay the NHS surcharge, which is in the region of £1,650. So potentially there is a saving there of just under £2,700. So that's what a fee waiver application is. You're applying for an exemption from paying the Home Office fees related to your visa application. That's the context. Specific question is, how long does it take for an application to be decided? Now, every application is different. It may well be that you've submitted an application which is very thorough, very straightforward, and you could expect to get a decision much quicker. On the other hand, you could have submitted an application where the Home Office feels that they need to come back to you, that they need to ask you more questions, they need to investigate your application, and it could result in your application taking longer. So it really does depend. But to give you an idea as to how long these applications take, in my view, they're taking in the region of about 3 months to be decided. So that gives you a rough idea. Now, straightforward application, you may get the decision a few weeks earlier. Something more complex may take a little longer. Now, that's a rough guide. In practice, what I have seen is this, and this is the case for the vast majority of fee waiver applications. The applicant or the applicant's lawyer makes the application, tries to provide as much information as possible in relation to the applicant's finances so that potentially the application will be successful. However, the Home Office, generally speaking, will always come back and say, look, you know what, we've looked at your application, we have an issue with this, or we want to query that. And you're asked to answer a number of questions, quite probing questions relating to the applicant's finances. And then that information is sent back, it's assessed, it may be accepted, or it may trigger a further round of inquiries. So the reality is the Home Office, when you make a fee waiver application, doesn't agree to the fee waiver application straight away. They do come back and they do make inquiries in relation to your application, which could delay matters from 3 months. It could end up going to 4 months. But that's roughly what you're looking at when you're making a fee waiver application. Now, just on that, let's say you get the decision. It can either be successful or obviously it can be turned down. Either way, whether it is successful or whether the fee waiver application is refused, you will be given 10 days to submit your FLR FP application. So that's the kind of timeline that you're working to. Hopefully your application will be successful. You will then be able to submit your FLR FP application, and there will be no fee to pay, no application fee to pay, no NHS fee to pay. So that's roughly how this fee waiver process currently works. Hope that answers your question. If you're not sure about the answer I've provided, or there's a follow-up question that you want to put to me, by all means, send me a WhatsApp message, or alternatively, please do call on the landline number and you can speak to me live and I can clarify any issues that you have. Now, next question. We've got a number of questions which have come in. Next question on WhatsApp. It's quite a lengthy question, quite an interesting question, slightly different. It's to do with immigration again, but it's to do with refugee status, somebody who has refugee status, somebody who's applied for indefinite leave to remain, and they are experiencing difficulties. And it's quite an interesting question. Let me read the question out and let me then go through it. I think it's for the benefit of a lot of our viewers who may be in this situation. And our viewer puts the following question to us. I have a question in relation to my mother's indefinite leave to remain application. She applied more than a year ago, 1 month before her refugee visa expired. It's been 15 months, but she hasn't received a decision yet in relation to her application. Actually, she made a mistake in her application, not knowing the law properly. She renewed her passport from Pakistan embassy. So she's obviously a Pakistani national, and she's applied to extend her, or she's renewed her Pakistani passport. Someone helped her with the Pakistani passport application, as my mother was intending to go for Hajj. It looks like this might have confused the Home Office as to why somebody with refugee status had applied for a Pakistani passport. The basis of her asylum claim is relating to religious extremism, factions possibly targeting her, possibly making her life difficult. She belongs to a religious minority group, vulnerable person, abandoned the children in Pakistan and came to the UK. Now, it's a difficult situation to be in. On the one hand, mother has refugee status. She's applied for indefinite leave to remain, so I assume she's completed 5 years in the United Kingdom with refugee status. The difficulty that we've run into is that mother has applied for a Pakistani passport. Now, if you look at the Home Office guidance, what it does say is there are some triggers. There are some circumstances in which the Home Office could revoke refugee status, or certainly look into it. And applying for a passport from your own home country is one of those situations where the Home Office could investigate the matter further and revoke her status. Now, what I'm going to do is we're going to be taking a short break. This is quite a complex matter. So what I will do is address this in greater detail after we come back from our break. It is an important question. And let's look at this after we come back in the next couple of minutes. Inshallah, see you in the next few minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, if you want to send us a WhatsApp message with your question, you can do so by sending that message to the mobile number which also appears at the bottom of the screen. As always, we've had a number of WhatsApp messages coming in with your questions. And just before the break, we were looking at the question relating to our viewer's mother, who had been granted refugee status. I'm assuming she'd completed 5 years in the United Kingdom, and she was applying for indefinite leave to remain. Run into some difficulties, and the difficulty really is that mother, our viewer's mother, had applied for a Pakistani passport just before the indefinite leave to remain application, and the Home Office, I'm assuming, has become aware of this, because in the application it may well be that the details of the new passport has been given. Now, as I was explaining just before our break, there are certain circumstances in which the Home Office can reconsider your refugee status. And if you look at the guidance which is on the Home Office website relating to refugee status, when refugee status can be revoked, there's a specific guidance which deals with this. That guidance says that there are certain things that may occur which could result in the grant of refugee status being looked at again. And there is a section which specifically says where you have applied for a passport from your home country, the country from which you are fleeing, that could result in the refugee status being revoked. Now, the good news is this, that it doesn't say that just because you have applied for a passport, refugee status must be revoked. It doesn't say that. It is a possibility that refugee status may be revoked. Then what can you do to address this? Then you simply, and I think you've probably done this because part of your question towards the end stated that you had contacted your local MP. Now, what I'm sure you've done this, but you need to go back to them, emphasize to them that, look, there was a very specific purpose for making a request for applying for a Pakistani passport. No intention of returning to Pakistan, no intention of seeking the assistance of the country. You've got refugee status from there. You simply needed a passport to go for Hajj. I think that's what's been put in the question. And that was the purpose behind it. And so in those circumstances, it shouldn't necessarily lead to the revocation of one's refugee status. So that's basically where we are. You can go back, you can put your points to the Home Office. You must do that. Seek the assistance of a lawyer if need be, and your local MP, and get your point across. I hope that the matter does get resolved in your mother's favour in the not too distant future. Thank you very much for your question. Just one additional point before we move on. Once you do have refugee status, you do need to be careful about obtaining a passport from your home country, returning to your home country, etc. There are certain circumstances in which refugee status can be revoked, so do be careful of that. Okay, let's look at the next question that's come in. A brother who sent the question in, Brother Shazi, who says, the question I want to ask is this: how long is the Home Office taking nowadays to make a decision on an application based on 20 years FLR FP? One of my friends has been waiting for more than 6 months. What should we do next? Now, again, let's explain the context to this question. An FLR FP application based on 20 years residence is normally an application made by somebody who has overstayed in the United Kingdom, that might have come legally, might have come to the UK unlawfully. But whatever the means and method of entry was, the person in question has lived in the UK for 20 years. Now, that residence may be lawful, partly unlawful. It might be totally unlawful residence in the UK. But there is a specific rule in the immigration rules which caters for the situation where someone has resided in the United Kingdom for 20 years. After 20 years in the United Kingdom, it is possible to apply for leave to remain in the United Kingdom. So not indefinite leave, simply for leave to remain in the United Kingdom. And that leave to remain ultimately leads to indefinite leave to remain after another 10 years. So it's a long road to indefinite leave to remain. So that's the context. Somebody who's been in the UK for 20 years, now they're ready to apply, and they have applied for leave to remain based on their 20 years, most probably unlawful residence. How long does it take? Now, I've done a couple of these applications recently, and it is not unusual for such an application to take 6 months. Again, in my experience, you normally get two types of applications. One is where somebody who's, been lucky maybe, but they've kept everything from when they came to the United Kingdom. It may well even be that in those days it was possible to open a bank account. They opened a bank account. It was easy to register with the GP. They registered with the GP. And now 20 years down the line, they've got the documentary evidence that the Home Office asks for where you're applying under the 20-year rule. Because the Home Office doesn't just say, all right, you're saying you came on this date, you're saying you've lived in the UK for 20 years, and therefore, based on your assertion, you're going to be granted a visa. The Home Office doesn't operate that way. They want you, the applicant, to prove that you've been in the UK for 20 years. Yes, you may have an entry stamp in your passport, which confirms your date of entry, but that's not enough. You must prove from the date of entry you have resided in the United Kingdom. Now, imagine how difficult it is for somebody who is living in the UK unlawfully. They may not have bills in their name. They may not have bank statements in their name. They may be scared to see the GP. So the kind of documents that you and I would generate, they simply would not exist. Now, that having been said, what you tend to find is two different types of applications. One is where somebody has a lot of evidence of residence in the UK, and you put it together properly for every year. Maybe you've got 7, 8, 9, 10 documents, and you've done that over the last 20 years. And that's an easy application. Contrast that with an application where we don't have much documentation. That's going to be difficult. That's going to take a long time. But 6 months is not unusual at all to get a decision. It may take another couple of months, but hopefully not too much longer. Hope that answers the question. Let's take our next call. Hello, assalamu alaikum. Hello.
Hello, assalamu alaikum.
Ji, walaikum salam. Ji, brother, thank you for calling.
Yes, brother, I got a question regarding, I have done my hearing 3 weeks ago.
Okay. Okay, brother. Yep.
Yeah, can you hear me?
I can. Loud and clear. Please, brother, carry on.
Yeah. So I have done my hearing 3 weeks ago. I just want to know how long does it take for this decision
Okay.
to be made?
So you know when you went to the hearing, did the judge give you an indication as to how long it may take for a decision? Did they say to you?
No, he did not.
Okay, the judge never gave you an indication, right? I'll tell you in my experience how long it takes. Now, I don't think tribunals are that busy with cases at the moment. Now, in my experience, it's taken about 3 weeks to get a decision. About 3 weeks. Probably shouldn't really be taking more than 4 weeks to get a decision.
More than 4 weeks, yeah?
Not more than 4 weeks. I'm assuming, I think you're calling from Kent, so I'm assuming it would have been one of the London hearing centres that you went to.
Yeah.
London hearing centres might be slightly busier than some of the hearing centres up north, but 3 weeks, I think tops 4 weeks is a good guide indication as to how long it does take. Now, what you can do is, if 4 weeks go by, you can phone the tribunal up to see whether there is a decision or not that's been made. They won't tell you what the decision is, but they can tell you if a decision has been made or not. So,
okay.
They won't tell you on the phone what it is, but they'll tell you. So I think give it another week and then give the tribunal a ring. There might be a decision waiting for you.
Okay, thank you very much for that.
Thank you very much for your call. Thank you very much indeed. Thank you. Assalamu alaikum. And best of luck with the decision and the outcome of your hearing. We get a number of questions in relation to delay, in particular in relation to how long the Home Office is taking in making decisions. We went through slightly unusual circumstances last year. A lot of offices closed down, and it took a while for the Home Office to get used to maybe remote working, like a lot of us. But things are going back to normal. Things are running more smoothly, smoother than before. Certainly in terms of the tribunals, they've started getting people to attend in person. And so it is getting better at the moment. So a lot of the backlog has cleared. But in answer to the specific question, how long are tribunals taking to turn decisions around? About 3 to 4 weeks is normally enough. Hope that answers your question, and best of luck with your case. Another quite an interesting question that's come in relating to somebody who is here, I'm assuming, on a spouse visa, but they're experiencing difficulties with their marriage, looking at what could happen. So somebody here on a spouse visa experiencing difficulties with their marriage, can you extend? Can you apply for indefinite leave to remain? What's going to happen to your visa status if you find yourself in this unfortunate situation? We're taking a short break. I'll answer this specific question after we come back from a break. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, you can send me a message, a WhatsApp message on the mobile number which also appears on the bottom of the screen. I'll get your message here live in the studio and I'll be able to address your question live on air. To speak to me live, please do call on the landline number. Okay, we've had a number of questions coming in. Just before the break, I explained that we'd had a question come in, interesting question, relating to somebody who was here in the UK on a spouse visa, and they have run into some difficulties with their partner. We're looking at the impact of that on the spouse visa that this person was either on or is still on. Let's look at the question and then address this in greater detail. Our viewer says, hi, my question is as follows. If a male has been in the United Kingdom, working, paying their taxes, but his spouse cancelled his visa due to a breakdown of marriage, can they legally remain in the United Kingdom? What appeal rights do they have as a single individual? And I think to complicate matters, I think now you were saying that the person is on police bail. We don't know what the police bail relates to. But I think initially the position is this, that, or the question is this, that a male who's been working in the United Kingdom, legally working on a spouse visa, the spouse has cancelled the visa due to a breakdown of the relationship. Now, unfortunately, this is a common occurrence. And let's look at what happens and what you can do as an individual. I don't know where we are in terms of timeline. I don't know whether the visa has been cancelled and you've overstayed, or you've received a letter stating that your visa is going to be cancelled. So I'm not too sure where we are at the moment. But look, this is what happens. A spouse visa that's granted, a partner visa, or however you describe it, normally, initially, it's for 2.5 years. After 2.5 years, it's extended for another 2.5 years. If everything goes smoothly, it results in indefinite leave to remain after 5 years. You've got to view it as a visa where if your marriage is to break down, you will not qualify for indefinite leave to remain after 5 years in the UK. It's a probationary type visa. If things work out, you remain married, you potentially qualify for indefinite leave to remain. If in those 5 years there's a problem, marriage doesn't work out, marriage breaks down, as is the case here, then you cannot get indefinite leave in that category. You're going to have to look outside that category. Is there something else that you can go into? Now, how does the process work? It could be that, let's say you've got your 2.5-year visa, a year into your visa, you've run into difficulties, spouse has informed the Home Office that the marriage has broken down. If that's the case, the Home Office will write to you and ask for your comments. And if ultimately the Home Office decides to curtail your visa, they will normally give you 60 days notice of that. So if they were curtailing your visa now at the end of October, you would have until the end of December of this year. So you will, if the decision is made to curtail your visa, you will have 2 months notice of the curtailment as to when the curtailment will kick in. Now, a couple of points. I normally advise my clients, look, if your marriage has broken down, there's no way you're going to get back together again, and there is now a danger that your spouse will inform the Home Office that the marriage has broken down. Be proactive, tell the Home Office your new address. And the reason for that is you want to be able to engage with the Home Office if the Home Office try to contact you, try to inform you that your visa is going to be curtailed. You can put your position to the Home Office, and ultimately it leads to where there's a marriage breakdown and there are no children, it could lead to the curtailment of your visa. If that happens, you've got notice. You know you've got those 2 months notice before your visa is going to come to an end. Now, why is that important? It's important because it gives you the opportunity to take any additional steps that you want to take. And we don't know what's happened here. It could be that you're able to submit an application based on domestic violence if you have been the victim of domestic violence. So, okay, your spouse is curtailing your visa, but you are moving into or making an application under a different category. So domestic violence, if applicable in your circumstances, is something that you would look at, is something that you could apply for if it applies to your situation. If you've got children, you could make an application based on your children. If contact or access hasn't been established and you're going through the courts, you could advise the Home Office of that. If they don't agree with what you're saying, you could potentially make an application for leave to remain based on your children, not your spouse, based on your children. So what we're doing here is looking outside the current category that you're in. You're here in the UK with a spouse visa. Now that there are difficulties, you're looking at outside. Can you apply under the domestic violence rule? Can you, if you've got children, can you apply on the basis of children who might be living with you, or you might be seeing the children once a week, for example? That's the common scenario. Now, if it transpires that neither of those two applications are open to you, you could still look at alternatives. It could be that maybe there is an employer out there who is willing to sponsor you. You could potentially look at moving from your current visa into a work permit type visa. So again, we're looking at moving out of the spouse visa route into another visa. If you're interested in studying and you're able to get sponsorship, it may be possible for you to move out and go into a student visa. If you've been living in the UK for a long time, you could apply on the basis of your residence in the United Kingdom. So the point I am making here is this, that all isn't lost necessarily. There may be options, avenues open to you. So if you do find yourself in a situation where your marriage has broken down and there is a real possibility that your visa is going to be curtailed because your spouse has informed or will inform the Home Office of what's going on, seek advice from an experienced lawyer, an experienced immigration lawyer. They will be able to advise you as to your options. There are a number of options. I'm not pretending that these are easy options, but there are options out there, from making, if applicable, making an application under the domestic violence route. If you've got children, an application based on your children. If you're lucky enough to have an employer out there who's willing to sponsor you, to move out into that. If you can go into a student visa, to go into that. And it may well be, look, this is an unfortunate situation. These things do happen. If your marriage has broken down, if you've divorced, you're about to divorce, it may be that it's possible for you to find another partner, remarry in the United Kingdom, and make an application based on your most recent marriage. So there are options there. Ultimately, if none of the above apply, the difficulty is this, that your visa would come to an end. In answer to your specific question, look, the applicant has been paying taxes for a number of years, been working legally for a number of years. That doesn't necessarily help at all. The different applications that you're going to be making, they won't succeed just on that. Because as a single person, and we've touched upon this just before, as a single person, if you don't fall into any of the other categories that we've discussed, and there's no domestic violence application that can be made, can't make it on the basis of the child, there's no job, there's no studies that you can go into, none of that applies. All you've got is you're single and you've been living in the United Kingdom, paying your taxes. That's all well and good, but they won't give you a visa. The Home Office won't give you a visa on that basis unless you've lived in the UK for 20 years. Or if you're lucky enough to have completed 10 years of lawful residence, then potentially you could apply under the 10-year lawful residence. But that all gets tricky because normally somebody who's here on a spouse visa is only in the UK. They've only been in the UK when they're facing such a situation for 2 years, 3 years, 4 years. They're not normally able to rely on the long residence rules, whether it's the 10-year rule or the 20-year rule. But I think the key question here is this. It's an interesting question. The key question here is this, that, this is a classic situation where you should take advice from a lawyer. You should discuss your options. Even if none of the options seem very attractive, there may be ways of keeping your status in the United Kingdom legal for a little longer, which gives you time to look at alternatives. So that's where you are. Interesting question there. Okay, we've got another question that's come in, and again, it relates to a spouse application. A lot of questions coming in for immigration and spouse applications, and this one is to do with the English test. And our viewer is asking about the English test. Specifically, it's a question relating to when a person can be exempt from the English test. So we've got somebody here who's been trying to pass their English test for a while. Now, this is the test you pass in order to come to the United Kingdom as a spouse. And what's been put to us is there a way around this English test? I think the spouse has been trying for a while, not been able to pass the English test, therefore there's a difficulty in applying. So what's the way around it? Is there other options? We're going to be taking a short break. After we come back, let's look at this question about the exemptions to the test. See you in a bit. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, you can, as always, send your messages through to me on the WhatsApp number which also appears at the bottom of the screen. As always, we've had numerous questions coming in on WhatsApp, which is fantastic. But you can, as I always say, pick up the phone and give us a ring on the landline number as well. So just before the break, I was explaining that we had a question in, immigration law question, particularly relating to spouse applications, where somebody wants to sponsor a partner to come to the United Kingdom. And the particular question being posed to us is in relation to the English test. And what's been asked is basically this, that a viewer is saying, my partner is experiencing some difficulties in passing the English test. Is there a way around it? Are there any exemptions to that? Now, as our viewers will be aware, certainly those who have gone through this immigration process, where one sponsors a husband or wife to come to the United Kingdom, there are various requirements that need to be fulfilled. requirements ranging from financial requirements, accommodation requirements to the English language requirement. The last requirement, the English language requirement, has been with us for now probably about 10 years or so. Basically what it is that anybody coming to the United Kingdom on a spouse visa has to pass an English test. Now, in my experience, the vast majority of people are able to pass the test, but obviously there will be people who find it difficult to learn a second language and to pass the test. And sometimes it's the older generation who have greater difficulty in passing the test. Question is there a way around it? Unfortunately, there are only very limited exemptions to that. And what you sometimes come across is if the person applying for the spouse visa is 65 or over, they are then exempt from the English language requirement. If they are not of that age, then normally you can only apply for an exemption if you have an illness which prevents you from passing the test. So it's not that easy. There has to be medical evidence which is submitted with the spouse application. The Home Office has to be convinced that the illness is such that it is not possible to pass the English test. So one is the age exemption, the other is the medical exemption, where based on somebody's illness, you're saying that you should be exempt. Now, if none of those two apply, then unfortunately the test does apply, you don't fall within the exemption, and therefore you have to pass the test. Without passing the test, the application is likely to be refused. So that's where we are in terms of that question. Okay, let's look at the next question that's come in. Question is this. I've been in the United Kingdom on a Tier 2 visa since November 2017. My BRP card expires on 15 November 2022. When can I apply for indefinite leave to remain? So somebody who is here on a Tier 2 visa needs to complete 5 years in the United Kingdom before they can qualify for indefinite leave to remain. So, starting point is this, that if you're here on a Tier 2 visa and you're looking at making an application for indefinite leave to remain, you're working out when you can apply, then the starting point always is look at your date of entry into the UK. When did you come into the UK? And whatever the date of entry is, look ahead 5 years. So if, let me give an example, somebody came to the United Kingdom similar to what we have here on the 10th of November 2017, then 5 years from that date will be 10th of November 2022. So that's when the 5 years will be completed. So if you remain in the United Kingdom on this Tier 2 visa for 5 years, it takes us to from 10 November 2017 to 10 November 2022, we've completed our 5 years. You're able to apply for indefinite leave to remain at that stage. So 10th of November 2022. The only other thing that you can do if you want to apply a little earlier is that you can apply 28 days before the 5 years are completed. So if the 5 years are completed on the 10th of November 2022, then you potentially 28 days before would be around the 13th of October 2022. So that's the date you'd be looking at. So work out 5 years ahead, and that's the date when your 5 years are completed. You've got the date. The earliest you can apply is 28 days before that date. So hopefully that answers that particular question. Now, for our benefit of our viewers who are interested in work permits in the Tier 2 scheme, what has happened in this particular year is that there's been a significant change with the way the work permit scheme works. We no longer have the Tier 2 scheme anymore. We now have a skilled worker scheme. However, if you have a visa under the Tier 2 scheme, then you can remain within that scheme and, once you've completed the qualifying period, apply for indefinite leave to remain on that. But as far as new applications are concerned, those who are coming to the United Kingdom for the first time, or they are going into this work permit scheme, terminology is different, although the process is very similar, been made slightly easier, but the process is very similar. The visa that you're now granted is the skilled worker visa, not the Tier 2 visa. But if you've got the Tier 2 visa, all well and good, please do stay within the Tier 2 visa scheme and carry on until you get your indefinite leave to remain. Okay, hope that answers your question. Next question, another question relating to a spouse visa or a question based on relationships. Question is this: my friend is a British citizen. She wants to marry somebody who has no status in the United Kingdom. They have no pending application before the Home Office. What can be done by that person? Can they get married under Islamic law? What's the position as far as visas are concerned? Now, again, in practice, this is quite common, where you have, unfortunately, people who have overstayed for whatever reason in the United Kingdom. They're without any kind of leave, and they do experience difficulties in that situation. Now, if they form a relationship, this is somebody who's overstayed. If they form a relationship with somebody who is a British national, there is a possibility that they would be able to obtain leave to remain in the United Kingdom. However, normally an application from an overstayer based on a relationship with somebody who is British will only succeed normally where from that relationship there is a child. Now, there are certain circumstances where even without there being a child from that relationship, your application can succeed. But generally speaking, the cases which are most likely to succeed, where there's a marriage between somebody who's overstayed, somebody who's married a British citizen, the person who's overstayed has married a British citizen, that when the person who's overstayed applies for leave to remain, the application is most likely to succeed where there is a child from the relationship. There are limited circumstances where you could still qualify, but otherwise there are difficulties unless there's a child from the relationship. Let's look at the next question that's been coming in. Assalamu alaikum. I am only getting paid minimum wage for the 80 hours I work per month. For the other 90 hours that I work, for the remaining month, I get paid £6 an hour. So this is an employment type question. And what's been put to us is that the employer, for whatever reason, appears to be paying properly the national minimum wage for 80 hours of work per month. The remaining 90 hours, I am assuming you're saying, because I don't have your date of birth, and the date, your age determines what the minimum wage is, but I'm assuming for what you're saying is that the 80 hours is paid properly in compliance with the national minimum wage. The other 90 is not paid properly. What are your options? You should raise a grievance with the employer saying that it's unacceptable. You must pay the national minimum wage. You must do that. I mean, that's your right to be paid the national minimum wage. So you should raise a grievance. If the employer tries to dismiss you following the grievance that you've raised, you potentially have a claim against your employer, irrespective of your length of service. You might have just worked there 2-3 months. your employer can't dismiss you if you've raised concerns about the way you're being paid and you're dismissed because of you raising concerns. Raise your concerns through grievance. Other option is that you could issue proceedings in the employment tribunal for the difference. Let's say you're entitled to be paid £8, I can't remember what the national minimum wage is, £8.36 or whatever the right rate is, you're being underpaid. For that difference, you could bring a claim to the employment tribunal. Third option, you could report the matter, and I think the authority that looks into this is the HMRC. I think HMRC has been given the responsibility for ensuring compliance of the national minimum wage laws. So you could raise a concern with HMRC. So a number of options open to you: raising a grievance, going to the tribunal, or informing HMRC. Hope that answers your question. If you're not sure about the answer I've given, please feel free to come on the phone and speak to me. Unfortunately, as far as today's concerned, we are coming to the end of the show. However, we will be back next week, so please do continue to send us your message and to give us a ring. See you next week.